Good afternoon. It's August 2nd, 2023. My name is David Puckett. I'm founder and CEO of what today we're calling Cognitive Resolution Solutions. The purpose of this video is you'd think after 10 years of being in business, we would have everything figured out and a direction, but we haven't. This industry, known generically as online dispute resolution, ODR, is a brand that I've disassociated myself with 10 years ago. Conceptually, online dispute resolution is seen as video conferencing for mediation. And I have a problem with that. It has created, just like the ADR brand, alternative dispute resolution. The word alternative was key, alternative to the legal industry. Well, the last 20 plus years, slowly but surely, the ADR, or what was the ADR, alternative, was being gobbled up by the legal industry, and today the majority of all mediators are either active or former attorneys or retired judges. And in my opinion, there's a major need to return to ADR principles, dispute resolution without the nomenclature of brand mediation. Or if you're going to use mediation, we've coined a term we call old school mediation, where you go to mediation without your attorneys. 6 months, a year ago, I was at lunch with a friend. He goes, "Oh, you're a mediator, right?" I said, "Well, yeah, by practice and trade, I guess that'd be how you would say it." And he said, "Well, I hate mediation." And I said, "Why do you hate it?" He goes, "Well, it was a divorce." Of course, I knew what it was. So I'm paying my attorney. He sees it as his money. Her attorney, room rental for the mediation and the mediator. And it did no good. And there's a general belief that mediation, now adopted by the legal industry, and this is in no means a negative or cut on the legal industry or practitioners in it. There are some good ones. But there's just a general belief that mediation is to get a check mark for the judge that you tried it, and that mediation isn't even real. It's just a part of the step of litigation. And that's a shame, because when I became a mediator in the mid to late 80s in Hawaii, taught by my mentor and his wife at the time, Dr. Vector and Dr. Krista Slayton, they taught us how to do dispute resolution, and that mediation isn't even a legal process. It's communication, almost like facilitation between people. So I've made videos like this for a while. We went down the wrong path, and it's no one's fault but my own, that I believed that we could create a system, a platform that the attorneys would use to serve their clients differently and create a different economic model for legal services. Primarily there's these big mega firms that specialize in one or a few areas of law, and you just go to them and you have a legal need, and they're expensive. $300, $500, $600, $750 an hour is not uncommon in these days, and you pay for their expertise, and you pay for it on an hourly basis, much like corporate to engage attorneys. Two, we're very familiar with the retainer method, commonly used in divorce. Put the retainer up, bill against a predetermined amount, and that's how you get your representation. Contingency, we see a lot in automobile accidents. The largest and biggest brand in that space, one to be admired because they revolutionized that space, is Morgan & Morgan. But they typically take 40, even 50, not Morgan. I don't think Morgan & Morgan takes 50%. Maybe they do. Sometimes they may take 30, 20, but it's typically 40 to 50%. But of course, they're responsible for all the costs, the filing fees, the depositions, hearings, etc. And the client doesn't pay a penny until they recover. That's been the predominant model of the legal system. The legal system, the legal industry, has never been a technology innovator or mass adopter. I've been in the legal technology business for over 30 years, really dating close to 45 to 50 years watching my mom progress from an IBM Electra Selectra typewriter to dedicated word processing systems that had got typewriters as the keyboard, through various systems, billing and time and billing and case management software that law firms used. And so you've just always been adverse to technology. I remember when I made a speech once in a legal Florida Bar Association meeting about email and laptop computers, and I said, attorneys will someday have an email address, and they'll write and author their own emails, and they will generate and type some of their own documents. And that was revolutionary, crazy thoughts when I said it. And I watched law firms go through that transition. I was putting computers on desktops and laptops on the desktops of lawyers, and I'd see some of the people, I would call them the old school guys, they just put theirs on the floor. They weren't even going to use it. But when they weren't getting memos and scheduling and what email productivity, they put it back on their desk and said, train me how to use it. So today it's standard, but the industry hasn't adopted it. What is the court? Is the court a public service? It is. It's the taxpayers build these buildings. Less than a decade ago, about a decade ago, they built a Taj Mahal courtroom, I think in Tallahassee, Florida. It was millions and millions, and the cost of it was just, it brought a lot of attention, marble and cherry wood and just these big, traditional, beautiful justice buildings. Folks, we don't need those buildings anymore. Unfortunately, the cost of going to law school is enormous. Unfortunately, far too many are taking out loans. And then that just really puts you and ties you to those economic models of contingency representation and retainer representation. And it just doesn't work. 60 to 80%, depending on what statistics and polling and things that you've read. But it's for sure 60, and I think it's closer to 80. Can't even afford a lawyer in this society. They can't not only afford it, they can't figure out how to participate in the legal system. And that's unfortunate. I'm surely not making any humor about Walmart as a place to shop or Target. But, I've often said is define the demographics of our services from our company. It's one we've had challenges to figure out ourselves over the last decade. But today, I firmly believe in a window of time, it's sort of somewhere between 20 and 50. Probably our sweet spot is 25 to 50. I'd hate to think, as an example, you're 25 and you're already going through your first divorce or major legal thing. Most people are still getting their education and building their careers. But it's not uncommon that a 20-year-old or 25-year-old could get into some kind of conflict that needs dispute resolution. But that's our sweet spot, and I always say my clients are not likely to be shopping at Neiman Marcus or Saks or these other high-end retailers. They're probably shopping at Target, Walmart. And I really think majority of our customers are probably shopping at Amazon like I do. But all jokes aside, I don't know. There's really no humor. As reality is, if you've got money, the legal system is friendly to you. If you don't, you're at a disadvantage. The criminal legal system is so broken, it's as bad as the civil piece. People often ask me, are you doing criminal law? Well, that's my next hurdle, and I'm not afraid. But right now, my company's focused on civil law or civil disputes or disputes that typically end up in civil court. But there's no requirement. I'd say 90% of our disputes, targets of disputes, could be resolved without ever going to court or filing a lawsuit. So now, let me address the changes. 2023 has been a little bit of a challenge for me personally. I think some of my competitors thought I might have finally given up. I had some medical challenges. I had a couple heart stents. I call it clean the plumbing out. Good to go for another 30 years. But in all seriousness, it's been a challenging year. I put deferred. I didn't have health care for a bit. It's hard of being an entrepreneur and the sacrifices you make and not. So luckily, I got the health care. Luckily, I got the proper treatment, and then luckily, I'm not only normal or as normal as I ever be, re-energized. So what are we doing and why are we doing it? I don't know who's going to watch this video. I'm going to post it on LinkedIn. I'm going to post it on our TEDR. We don't prescribe, or I've been advocating for a decade branding, and it's not I'm as proud of the brand as what the brand represents. ADR was alternative dispute resolution. It's supposed to be an alternative legal system. ODR, online dispute resolution. It's just people are saying now you don't even need any of our software and capabilities and that. I think by the end of this video, I hope you disagree with that, because you can just do it all with Zoom or video conferencing technology. Okay? I don't agree. And then our brand is TEDR, Technology Enhanced Dispute Resolution. We have some of the greatest technology. We're about ready to launch what I consider the best, built on the patent that I've applied for, and it's pending. It'll be granted, hopefully. I don't see it before the end of this year, but sometime hopefully in the first quarter next year. And what it's built on artificial intelligence and emotional intelligence. When you start to try to differentiate some of the technologies and processes, and TEDR is a process methodology heavily augmented and complemented by technology. Technology Enhanced Dispute Resolution, TEDR. So we have a little YouTube channel. It doesn't look very good. I'm looking for a YouTube channel manager. I may outsource it. It needs to be professionalized, but there's some good content out there. In particular, there's a great interview about 18, 24 months ago of my mentor, the guy who brought me into the mediation business, and I had the opportunity and privilege to interview him. And I posted it, and it's a bit long. It's an hour, but it's really good at understanding where we've been and where we're going. And Dr. Becker's been so valuable to us, sort of like of counsel in the law firm. So where are we going? Well, we rebranded 2 years ago, Cognitive Resolution Solutions Corporation. There's not a website yet, but there will be soon. That's purposeful. I haven't wanted to say what we're going to do until I knew what we're going to do. And now I know what we're going to do, and it's going to come up. I've had, and I pointed out, I've got one competitor in particular. He's revered in the creator of this industry. And I don't agree with it. I have a lot of respect for him. I like that he advocates, at least theoretically, where I've been. We gave some thought and consideration to maybe collaborating or working together 12, 13 years ago. It's been about 12 years ago. But he seems to always hijack or borrow my thoughts, maybe even borderline plagiarize. So many of the people who have worked with me, for me, and been familiar with me have said that when they see various iterations of his former company found its website, and especially even today, and the company's involved today, he seems to duplicate or replicate what I say. So I'm not saying it's me as much as I'm speaking out of vast experience. I've been a mediator since the 80s, the mid-80s, longer than he or many others. That's why I'm 60 years old and still at it, trying to figure out how to make a living at it. And in all fairness, mediation was a wonderful gift when it was ADR, but it just, today it's not being used as what it was intended to do. I advocate non-lawyer mediation. You don't need your lawyers in the mediation. It's not a legal process, but lawyers would never willingly allow their clients. Don't forget, the attorney works for you. It's not the other way around. Okay? You can, as the consumer or the parties in conflict, tell your lawyer what you're going to do. You can say, look, I'll let you take this course. You continue. I'll follow your path. I'll pay your bill. But I'm going to try this. If I can resolve it, I can try it. And this is without you guys. But what we've built is a technology platform. And we look at the emotional intelligence. Again, I don't like that brand because it seems like emotional intelligence means IQ. No, it's not. All of us are emotionally different. About 90% of conflict is emotion. And we've got a unique way to assess, evaluate your emotional makeup. And our system is built to respond to you and to be utilized based on your emotional makeup. That's pretty powerful. Strong AI. I can't really talk much detail yet because it's part of the patent. I can just assure you we've kind of got it figured out. I've got competitors. I won't name them today, but people have said the legal industry is for where this stuff needs to be. And those competitors are primarily focused on the legal industry. I've sort of had the attitude, good, let them do it. The problem with the legal industry, and I'll use Florida as an example, and these people sit on these committees, bar committees, the individual jurisdictions, which we have about 20 of in Florida, even though everybody's answerable to the Florida Supreme Court. The chief judge and the staff bureaucracy of the jurisdiction, and they kind of interpret and do things a little differently, and they have different systems, different processes to get to the same end means within the parameters set forth in Florida bar. But some of those guys have tried some of this technology and they go, it didn't work. No, the technology worked fine. The integration didn't work. Okay. Everybody has a conflict. They want to feed it into the court system by filing, and then they want that come out of the court system, work, and then get it solved, and it's the settlement back in the court system. That's more difficult. The integration is more difficult than the technology. I've said a million times, I've been in technology business my whole career. It's not technology. It's the blending against the marketplace, the need of what the marketplace feels it's ready for. You couldn't have done Uber 25 years ago, but with applets, and it revolutionized the approach. So the technology is an enabler. It's still, and especially in conflict resolution, again, technology enhanced dispute resolution, is still very much some humans. It's the question is what kind of humans, and that's where again we're unique. I can't say a lot, but we don't need Supreme Court certified mediators. Can we use them? Sure. Could our system, if the Arizona bar or the Kansas bar wanted to use this and offer it, could they? Yeah, they can brand it whatever they want. The engine will be powered by Cognitive Resolution Solutions Corporation. Our engine, powered by. Brand it whatever URL you want. We've taken a lot of heat, and deservedly so. We've had a variety of brands. We started with Resolve, Haitian Creole word for resolve. We moved to Resolve now, Resolve without the E, because we couldn't, somebody already owned it and they wanted $100,000 for it. So we just dropped the E. Settle now. A lot of settles. Our competitors, Smart Settle, Cyber Settle. There's a lot of settles, and a really interesting judge that I got to know and was getting, considering how she could be involved in helping us build this thing and get it adopted by the legal community. She says nobody wants to settle. Settle's a negative word. So our most recent brand is avoidcourt.com. It's pretty in your face, pretty clear what we want to do. But folks, in all seriousness, again, we'll leave Cognitive Resolution Solutions will serve any court system you would want. I'd actually argue today, again using Florida as an example, if Florida, one of the 20 circuits or jurisdictions, or the Florida bar, or the court IT folks wanted to use us, probably the best way to use our company is consulting. You want us to help you write the requirements, software selection, functionality around an ODR system, hire us. We know what our two competitors that I dabble in the space, can and can't do. Actually, I feel they've been hurt from the lack of consulting. I come out of the Big Four. I worked for KPMG for a number of years. PricewaterhouseCoopers, EY, KPMG, Deloitte and Touche, and then a sort of a second tier of top consultancies. They're not tied to accounting firms. But once the consultancy comes in and defines and understands the business, the needs, the client needs, the systems, they can write the requirements. And then the vendor is contracted to meet those requirements instead of people who don't understand the technology truly, where it's going. They're too into this how it has been, the way it is, and the way it's always going to be type stuff. So the quicker we get consultancies in this space, the quicker the adoption of the technology will be. Okay? So, cognitive. We're going straight to the consumer. I don't want to cost a small claims court in the sky. That's a term that's been mentioned. Sort of a theoretical description of what we could be. We're not in a courtroom. You're not going to court. Avoid court. A new way to resolve disputes. Some will argue, sorry, my nose is itching today. I apologize. It's rude on the video. Some people argue you can't get a dispute, or you can't have a dispute without a lawyer. And I kind of agree into that as far as it's important you understand your legal rights. Use divorce as an example. Most people don't understand how's child support determined, how's a percentage of parental custody determined. Not as much today, but still around alimony, and do I qualify? So these are things that attorneys can ask. And so within our methodology that built into the technology patent and the service methodology refinement of TDR, we urge you to use an attorney, but use the attorney not for litigation, for advisory. Pay them a fair hourly rate, what they want, to give you the legal advice, and then come over to our system and process it and resolve it. You don't need to go to court. Pretty radical. Some people go, oh, the lawyers are going to come after you and sue you for UPL. Come on. What do you call it? LegalZoom got sued. Uber, Lyft. Anytime you disrupt, you're going to get sued. But the problem is when you're disrupting in the legal industry, an attorney with an active license and member of a bar can sue you for free. And that can get a little annoying and challenging to the operation of the company. So a lot of people that might have gotten this space fear being sued for unauthorized practice of law. I have no fears. I call it David, that happens to be my first name, Goliath, the legal industry. Bring it on. I'm not giving legal advice. It's like Lucy and Charlie Brown. I think 5 cents for psychiatry advice. It was cute in the Charlie Brown, but it's illegal. Lucy isn't a psychiatrist. She's not licensed or educated. But in reality, it's funny. We have a mental health challenge in this country. And like the legal industry, the parallel is the majority of people can't afford to participate in the legal industry. The same is true, unfortunately, with the mental health industry. They can't afford to participate. They can't afford a psychiatrist. So we go to our friends and family for psychiatric advice, but the psychiatrists and psychologists that are renting office space in these little strip centers and stuff that you often see these folks at, private little home or whatever, they're not going to sue you for an unauthorized practice of psychology. So we got a lot of latitude here. And so, folks, I'm going to try to widen this up. My goal is 30 minutes or less. I'm at about 25. Cognitive Resolution Solutions is dedicated to building dispute resolution system platforms. And we have a variety of platforms, a variety of URLs. We're going to market with a product called avoidcourt.com, but it's powered by the engine. And I'm not going to give a lesson and take hours and hours about software development, but we're mentally used to buying Windows version 1, waiting at 2 to 3 years for Windows version 2, Windows version 3. Most people know Microsoft said they didn't even get it right until version 3. It's very common, okay? It's the same with the ODR industry. But today, in iterative software development and cloud-based software development, you write it once, you upload it. You can upload and add new features nightly. There's no manuals anymore. These apps are so intuitive. We're so used to using them. They're all so common. They're built on components. There's a thing called a component store. If you want a calendaring function, if you want a workflow function, you want any function, you can buy the component. And we're blending and matching these components for rapid software development, unlike anything before. And we have traditional software that runs on a laptop or a server or a desktop. Today, these are applets. It's an Android phone, that's my choice. When you're doing software development, you need an Apple applet. It's a little harder to get the certification, and an Android applet. That's what we do. We can take some of your requirements and build it for you. Okay? So I want to clear up any misunderstanding. Now, in conclusion, people have laughed at my websites. Couldn't you do better than that? Your website doesn't have all your pricing. It doesn't have a lot. Well, we've never gotten serious through matching clients' need and opportunity in mass. eBay's using this kind of technology. They have been for, I think, a couple of decades. There was a period of time they were resolving 60, 70 million cases a year on using online dispute resolution technology. We're trying to find 3 to 4 to 5 pilot projects in the coming year, 2024. We're beyond COVID. There's more acceptance. There's an understanding of video conferencing, bandwidth availability of video conferencing. So it's perfect timing for this, for us to come out and do this now. And so I'm going all in, and in the coming months, you're going to know what we're doing. Our websites are going to look better. Our brands are going to be better defined. We're putting together a top management team and board of directors. And now I've been patient. I've been setting back. But now it's time for us to jump in and jump all the way in. And I have only one goal: to open up the legal system to a 60 or 80% of people who can't afford to participate. Yes, I'd like to make some money in being one of the, we're not going to be the only one. I figure we're going to have half a dozen competitors, and that's fine. There's millions and millions and millions of conflicts. Okay, we're out trying to raise money. That's the challenge. And we're going to follow the Uber model, where Uber really launched in San Francisco, worked itself, refined it, and then went out and got big money. And we're going to need big money. I'm talking about 100 million plus big money. And or we want to sell out to a major technology company. We'll entertain both, and then future in that. Our goal is to disrupt the legal industry. What's been the traditional legal industry. It's sort of, we built it and they didn't come, using the analogy from the Field of Dreams Kevin Costner movie. We built Settle Now engine, hoping the lawyers would come and use it. They didn't. Okay? We're going straight to the consumer. We're going straight to business, B2C. We're going to offer mediation clauses for your contracts that serves your clients better. Today's social media driven world, used to we fear a lawsuit by a business or a complaint to the Better Business Bureau, for even the people who've ever looked at the Better Business Bureau. But today, the internet and social media can run a business. So it behooves businesses serving clients to resolve disputes quickly, without litigation. There's no record of it. Does the Better Business Bureau even really truly exist? I'm sure it does, but does anybody use it? We don't have time. And so we believe that it's important, this mediation clause, to getting businesses to resolve conflicts confidentially. So let's say something like, if a dispute arises as a result of this contract between the two parties, both parties agree to immediately proceed to confidential process hosted by a third-party independent company, avoidcourt.com, to resolve dispute. If we can't resolve it within 30, 45 days, you preserve your rights for full litigative recovery. pursuit. So that's it, folks. That's an update on the company as we prepare for the future. Even our shareholders have been confused. So I hope this video clarifies. Thank you and good afternoon.